Legislation changes month to month, year to year. But over the last century, the changes have been astounding. Join Karen Woody and her students from Washington and Lee University to dig into 100 years of insider trading law.
All right, welcome back to Classroom Insiders for Season 2. I am joined again by two of my students. This is Professor Woody. I can't wait to introduce you to Allison and Emilio and their topic for this episode. So welcome, Allison and Emilio. Why don't you guys introduce yourselves and maybe tell us something about yourselves?
Hi, I'm Allison. I'm a second-year law student, and I am interested in regulation.
Perfect. Emilio?
Hi, my name is Emilio. I'm also a 2L here, and I took this class because over the summer I was interning with a judge in the Southern District of California, and my first assignment was a securities fraud case. And so I wrote the order granting default judgment, and it was a super interesting way to kind of get exposed to all of that, 10b-5, and so I enter all these words I've never really heard about. So when I saw that you were offering this class, I was like, oh, this sounds super interesting. And the reading has been just fun to just read.
Yeah, awesome.
Yeah.
I can't believe that's the first time I'm hearing about that. That's so fascinating. I'll follow up with you later about that case.
Yeah, I'll show you the order.
All right, good. Awesome.
Yeah.
All right, so you guys, obviously, this is insider trading. This is a podcast about insider trading to some extent, but this is sort of insider trading adjacent. And you guys, I think, are bringing up a really interesting new-ish topic here. So why don't you guys set the stage for what it is you're going to talk about today, and maybe have even some sort of debate or give and take between the two of you.
Yeah, we were looking mostly at the differences between different circuits on when when preliminary injunctions are granted. And we found that there are two primary standards that are used between the circuits, and we're specifically going to stay in the Second and Third Circuits today. So for the Second Circuit, they follow a statutory injunction standard where the SEC basically only has to show a prima facie case and a strong likelihood that the violation will occur again in the future. And that's it. And then the Third Circuit follows the traditional injunction standard.
The Third Circuit kind of rebukes the Second Circuit's way of doing these things. And so they like to stick to the traditional injunction standard with the four-part test, where it's likelihood of success on the merits, irreparable harm, balance of equities, and public interest. So they're not super convinced that, at least in these SEC actions, you could forego the remaining three prongs and just kind of stick with the first one, which is kind of where the Second Circuit's at. And I guess it's just in the name of enforcement and not wanting these people to kind of get away with their money while these actions are proceeding through. That's kind of the crux of what we're talking about, is who's right, what's the right move.
Yeah, so for those who are maybe listening and aren't familiar with what even an injunction is, set the stage of if you knew nothing about the law, what is it that this is addressing?
So a preliminary injunction generally is some form of equitable relief that comes before the trial and before any sort of judgment is granted by the district court. Sometimes it's done by a magistrate judge. And so one example that we're going to be focusing on is asset freezes. So preventing a defendant from moving their money around too much or at all before the trial happens.
Yeah, so fascinating, I think, area of the law. A lot of debate, even among the circuits, and then even certainly on a policy stance and just what should be allowed. Because you're right, this is before you're going to trial, and the SEC is freezing things or holding things because of the risk that someone. It's almost like a flight risk idea, but it's more for money and assets. So, really interesting thing. So you're saying in the Second Circuit, there's a lower bar for the SEC to get an injunction. Did I understand that right? So it's sort of better for the SEC?
Yeah. So even further than that, for asset freezes in particular, the SEC has an even lower standard than the normal statutory injunction standard. So to get an asset freeze, the SEC only needs to show a likelihood of success on the merits and show an inference that the party has violated federal securities laws, and that's it. So they basically nixed all the three last prongs of the Third Circuit's traditional test.
Wow.
And so that makes things a lot easier for the SEC to get asset freezes through and make sure that any money is available for disgorgement later on in the case.
Yeah, and I assume this happens all the time if it's that low of a bar that they just sort of like that's almost they always just pro forma like freeze some assets here. Is that I don't know if you know that, but just it seems like a pretty easy thing to just go ahead and do before you even get to the merits of the case.
Yeah, the statutory injunction standard in the Second Circuit started really early. One of the earliest cases that I found that lowered the standard for an injunction was from 37.
Oh, no way.
So that was before even the standard that the Third Circuit relied on for saying that they're not going to follow what the Second Circuit was doing.
Okay.
So the Second Circuit's been developing its securities law injunction standard for a long time.
Yeah, it seems like it. So you guys are gonna have maybe some sort of you're gonna sort of explain you have sort of explained these two different like ways of the or two different standards. And so now maybe you're gonna take a position on them. Is that what we think we were gonna do? Explain the pros and cons, or you guys go ahead. What you wanted to tell me?
Do you want
I guess, yeah, it's interesting. I think we have evolving ideas on this. And so we'll take positions, but I think as we've been talking just in the background while we prepare for this, we've been kind of convincing ourselves maybe of the opposite sides. It's been interesting, especially because right now with these, we're dealing with the SEC. This isn't like a private plaintiff kind of. They have a different standard, but at least for mine, for the Third Circuit, they kind of rely on a strict like application of the four-factor test. And the two cases that I relied on were SEC v. Chappell at the Third Circuit case and SEC v. Gentile. And both of those, they talk about the fact that, so I'll just start with Chappell, I guess, if that's, so it's a pharmaceutical company executive that he got accused of insider trading. The district court granted a TRO, and then that was then I believe it was the SEC moved to convert it to a preliminary injunction. So the court says that, okay, so they have this test that they have to prove. They talk about how the defendant is they're bringing up this conflict with the Second Circuit on how to apply, how we're going to grant this. And so the Third Circuit just chose to go with no presumptions, even for the SEC. And so they're saying that these other three prongs, the irreparable harm, where they have to show that there's a clear risk of future harm to justify an injunction, and so that they could prevent future violations, the balance of equities, so the weighing the harm to the defendant, such as like the stigma or the business restrictions again versus the public interest. And then it's saying that following these, unless their rationale is basically unless Congress made a very like explicit ask to override these, it's not for them to decide that we're just going to throw away these three prongs of the test. So absent explicit congressional authority, I guess, it's not up to them. So that was kind of what I gleaned from Chappell. I guess I'll throw it to you. I'm getting a little
So what I'm thinking is that clear statement rule is it makes things more difficult for the circuits or for the SEC to get an injunction, and making things more difficult for the SEC to get that injunction, it just increases the risk that any defendant, as soon as they sense that a proceeding is coming, they're just going to shuffle their money around and so that the government can't get to it. And that something similar to that is exactly what happened in Smith v. SEC, which is a Second Circuit case from 2011, which was in which there was an SEC enforcement action brought against David Smith, alleging that he defrauded investors of about $80 million. And an injunction was imposed by the district court against both David and his wife and froze their assets. And the magistrate judge held a hearing regarding whether or not Lynn's assets could be subjected to a freeze. and the assets held solely in her name were a stock account inherited from her father, a vacation home in New York, a vacation home in Florida, which was initially jointly owned, and a checking account opened in 2009. And the magistrate judge ruled that the assets were actually jointly owned because David had control over the account for 35 years, deposited money into it, and used it to loan money to the companies at issue. And Lynn had opened the checking account and transferred the house in Florida into her name only after the commencement of FINRA proceedings.
Oh, wow. Okay. That makes some sense now.
So the court found that, yeah, those are jointly owned assets and her money needs to be frozen too. And then the SEC sought to have the house in Florida sold because later on in the case, bills were piling up and the house was decreasing in value. And so they were trying to just preserve the status quo of the assets and make sure that the money was still there. And so
But this is all happening before there's a conviction or before there's a decision on the merits, right?
Yeah, it's all happening before there's a decision on the merit. And so the Second Circuit analogized the interlocutory sale of assets to a forfeiture proceeding. And it was not determinative, but it was instructive on how to apply the equitable relief. And so because the SEC's likelihood of success on the merits was sufficiently high, it was high enough to entitle it to an injunction and justify the more onerous burden of the injunction, because it's not a small thing to tell someone to sell their house.
No, you're getting at what is going to be one of my next questions, and maybe I'll hold off. But this concept of no, I'm going to ask now. But is this a signal to who will win on the merits? I have to imagine there's some sort of, it's almost like the pregame to some extent, if you win these asset freezes or not.
Yeah, I haven't been able to tell the final judgment on a lot of these. Chappell was decided only in July of this year.
Right, yeah.
So it's very recent. I think that it's not necessarily determinative, but it is kind of an important safeguarding measure to have, just because otherwise the government entirely can't recover, because this is a civil proceeding. There's going to be no penalty if the money's not there.
Yeah. Interesting. And then another follow-up to that is, I'll let you guys keep going. I'm going to pin my question for later when you're done talking.
I guess, I don't know, as I hear her talk about that, it does make me, it's stuff like this that really makes me feel like maybe I am pro SEC, maybe I am pro enforcement on this, just because if you only have that first prong to go after, like the likelihood to succeed on the merits, it does feel like maybe that is a little bit of okay, you have to put forth enough to kind of convince me that you pass this test here. And I think it is in Chappell, the court, they say, if you fulfill the first prong, the first and second prong, you're pretty likely to fulfill the second two also. The public harm and things like that. It's hard not to find that you're going to find that if you didn't find the first two. And it kind of makes sense to me that all you should be able to show is that you're likely going to succeed with this case to be able to freeze their assets and get these injunctions. I know that. So as I look at my notes, the court in Chappell, they relied on Weinberger versus Romero Barcelo. So they clarified that when it's appropriate for a statutorily authorized injunction to displace traditional principles governing injunctive relief, they acknowledge that Congress may intervene and guide or control the exercise of the court's discretion in issuing an injunction, but the court instructed that they should not lightly assume that Congress has intended to depart from established equitable principles. And yeah, so they also rely on,
that clear statement rule. Like, did Congress speak clearly about what they wanted to do? And
they also refer to Hecht Co. v. versus Bowles, Bowles. And I took a quote from that where they say, we cannot but think that if Congress had intended to make such a drastic departure from the traditions of equity practice, an unequivocal statement of its purpose would have been made. So in Chappell, they're continually referring to, if this is what they wanted, they would have said that. And I feel like that's really what they lean on to make their case. And I do have to wonder how different are the results going to actually be, whether they follow this test or the Second Circuit's test or the Third Circuit's test, I mean, I do wonder, and this is something that I've been trying to find, but I kind of had a hard time finding, is there a meaningful difference in the outcomes? Are they saving that much time? Because I think that would be a question that might be important to answer. Because if you're balancing, okay, this is at the end of the day, it's the government freezing or taking people's assets. Is it worth, do they really have the time to siphon it all off? These are really rich people, so I have to assume that they are able to siphon it all off, send it out to the Cayman Islands or the Swiss bank account while they're getting held up. But it's kind of,
yeah, I mean, you can see even just in how you all have described it, the balancing act here. I mean, you're right. I think this looks like a taking, especially before a decision on the merits. And now you have some real restriction of certainly money flow. And this could even lead to restriction of travel. Those are all similar. Like you're not allowed to leave the country, that kind of thing. And on the other side, and that feels maybe kind of egregious when you should be innocent until proven guilty kind of an idea.
right.
But the other side is exactly, I think, what you're saying, Allison, which is then all this goes away. There is no penalty. If there's no money left, and because they can do some clever means of moving it around, then this is all kind of for naught. So I think that it's a really interesting thought.
Yeah, and I've also been kind of flip-flopping on which one, because I also feel like the 4-factor test gets you to, or it can get you to a very similar place as the Second Circuit test pretty easily, because we have the likelihood of success on the merits, that's still there. The likelihood of irreparable harm, if there's no money left, then there's going to be harm that cannot be repaired. The balance of equities, I think it was in Chapel, they said that they still froze the Chapel's assets at the end. They got to the same place as the district court. But they said he'll be fine. He's not going to be living like a pauper. He's basically still going to, he still has his like income from whatever his job was. But he's not going to be on the streets if he doesn't have his assets available to him.
He was pulling like $6,000 every 2 weeks from his salary. So they were like, come on, like he's not going to be homeless.
And then because the SEC is like a government body, that kind of implies that whatever they're doing is in the public interest. So it satisfies all 4 of the factors pretty easily without having to rely on the statutory standard and the lowered standard for an asset freeze.
That's a really interesting thought. So my next question, though, is maybe outside of what you guys maybe discussed, but I sort of, when this happens in practicality, how much do you think, especially given this difference between Second and Third Circuit, how much is this potential judicial forum shopping? Does it matter which judge you get that decides whether or not your assets are frozen or not? Or, I mean, that's what I'm curious about, how this definitely can already go 2 different ways, maybe depending on which circuit you're in. Although I take your point, Allison, that maybe those end up in the same place either way. But I can imagine judges, because of that difference and because of the potential latitude here, you could have very different judges on these calls.
Yeah,
So,
I haven't really looked into all this, the forum shopping issue too much, but we were talking about it earlier, and I'm not sure how effectively they can forum shop, because I imagine the SEC is pretty limited based on like where the defendant is, where they can bring the suit. So I'm not sure.
yeah, and it's true that I mean, the SEC nearly always has jurisdiction in the Second Circuit because that's usually where things are traded. If they're on our exchange, there can be jurisdictional nexus in Manhattan typically. That often is why you see these cases coming through the Second Circuit, but there can be any other sort of jurisdictional nexus other places. But yeah, so I'm curious about that, because I'm like, maybe there are reasons you would try to make an argument that they have to bring this in a different circuit if you're going to maybe get a more pro-defendant law and or just judge. Who knows? Okay. Sorry, go ahead.
I think that the Second Circuit is probably where the SEC would try to bring it more often than not, just because it's so easy for them to do anything there.
Yeah.
But then if there's any sort of removal motion, I'm not sure if how that would go.
Right. And that's like a little even beyond the scope maybe of insider trading, which is my next question, which is, all right, so link us back to how will this play out, or what is the nexus in that sense to what we've been talking about? What is the insider trading maybe angle on this, if any?
I think that the insider trading angle is just like how are we going to get to the actual trial? And the SEC is going to have to show a prima facie case of insider trading. I think there was a more clear one in Chapel, because that one, I don't have my notes on that one.
No, yeah. I mean, no, you're right. Sorry, I don't want to interrupt you.
Yeah. But because in Chapel, they had to show that he definitely had the knowledge that what he was doing was trading on inside information, because I believe the FDA was going to deny a approval for something, and it wasn't looking good for him.
It was, yeah, sorry, I don't want to,
Go ahead.
It was pretty egregious because basically he worked for this pharmaceutical company, and then he also, I think, owned the fund that had 80% of that fund owned 80% of the shares from the pharmaceutical company. And then so during COVID, they were working on this drug called Lens, and they were doing these studies to try to get it approved. They were trying to do it under the whole emergency approval thing for COVID. And the FDA continually told them hey, this study isn't sufficient. You need to bump these numbers up on the sample size or start a new study, a confirmatory study. And they kept trying to squeeze it through without really doing much. They didn't really do anything to kind of assure I think it was the FDA, that they were making a good faith effort to get this to happen. So then they finally got denied. And then once the FDA made it pretty clear to him in plain letter English that, hey, this drug is not going to pass, he went and he sold a bunch of stock outside of the plans. I'm blanking right now. Sorry. Is it the 10B plans where you can trade in the windows?
Right. Yeah. 10B5.
Yes. So he went outside of that and sold $80 million worth of stock. And he even was getting emails from people on the boards. Then they were saying to him, what are you doing? And he just kind of ignored it all. So it was pretty clear to show that, hey, he knew he did something wrong. He definitely insider traded. And then, so I think that's why, at least on this one, even though they did the full analysis, they were definitely going to end up in the same place. And if the Second Circuit did it, I mean, I think it wouldn't have gotten to the same place.
And I think you're right that this is actually sort of something we don't touch on maybe as much as we should in this class, which is the real nuts and bolts of how we get from A to Z on these cases, including where does this money come from if you have to pay that back? And exactly this issue you guys are bringing up, which is what if the money's gone? What avenues does the SEC have to maybe try to lock that down? Balancing, like you said, the individual interests of not having their money frozen before they're maybe in theory found to be liable. So yeah, it's a fascinating topic.
Yeah, and I think, and answering your question, how it ties back to insider trading, I think coming into this class, that's something that I've always been curious about, especially just over time. You hear, to me, insider trading and these financial crimes cases have always been the most interesting to read about, just while I'm out in the world before law school or anything like that. And then as I'm reading them, I'm always wondering what's stopping these people from just, courts move so slowly, the government in general moves so slowly. So it feels like they're at this really distinct disadvantage when they're trying to combat these financial crimes and get money. And ultimately, a lot of times, I think from what I read, that money can potentially be used to pay back people who were wronged, who were harmed. I think, depending if they disgorge their ill-gotten gains. The question that I've always had is, how do they make that happen? And so that's why it feels like, to me, the Second Circuit kind of has it right. Even though that's not my position officially, it just feels getting there quickly and kind of taking this more agile position to at least freeze their funds in place. They're not taking them yet. They're just freezing them. And then to allow the process to happen without any funny business going on in the background. That just feels right if you care about justice. But at the same time, I understand that there's a whole other prong where the literature I was looking for that I wasn't able to find, and I'm wondering why if I haven't found it, if it doesn't exist, and I'm wondering why no one's written about it yet, because it feels like there's a constitutional issue here when it comes to freezing assets and seizing assets before final judgment. And I would be really interested to read about that, because we just got done with our Davis moot court problem, and a lot of that was a Fourth Amendment search and seizure type stuff. And at least when it comes to surveillance, there's all this stuff that's written about. But when it comes to seizure, at least with and the intersection of financial crimes, that's something that and now I'm really curious about, because I just haven't been able to find that much about this specific issue.
Yeah, I think asset forfeiture in any jurisdiction is very sort of, and I say that just because I'm in a group of people that deal with this worldwide, because so many of these assets get moved across state line or across national borders often, is hard. Everyone's trying to sort of get to the bottom of it. I don't know how much is written about it that much. I know there's been certainly a lot of uproar about criminal asset forfeiture, especially when things like for more sort of street level crime of like your car got impounded because of risk of this, or cash is found in your car and the cops just sort of end up taking that. I think John Oliver did like an amazing, one of his like deep dives was on something like that, which is a little different than this, because you're right, this is sort of more maybe high level, maybe high dollar amount of, and people with a lot of potential access to move money elsewhere. Yeah, I mean, maybe the answer is that you need to be writing that, Emilio.
One of my takes on the constitutional issue part that I was looking at for the Second Circuit was a lot of the justification for why the Second Circuit lowered the standard even further for asset freezes was because it's not going to last. An asset freeze isn't going to last forever. I believe in SEC v. Unifund SAL, it said that they didn't find enough to prove a prima facie case that was likely to succeed on the merits, but they did find enough that they decided to limit the asset freeze to 30 days. And it was only the amount that was like triple what was the ill-gotten gains from the alleged trading or alleged fraud. So because the court has the discretion to set those kinds of limits, it's not as burdensome as the statutory injunction standard for other forms of injunction, saying, hey, don't do it again, or else you're going to be in contempt, because that's more legal jeopardy to put a defendant in. It's not as burdensome as that.
That's interesting. I have to think about that. Yeah, no, I think these are really interesting policy arguments to make. And I think you guys have highlighted even some of the legal discrepancies that are also fascinating. So I can see why this will come up in every insider trading case likely, but then also in a much broader, any sort of type of criminal or civil enforcement action where assets might be, or ill-gotten gains and disgorgement would be potentially on offer for the regulator. So this is great. Do you guys have any sort of final thoughts or comments before we wrap up? Because I know I've kept you for a while, but this has been a fascinating discussion.
I think I'm good.
No, yeah, I think it's a cool topic, and yeah, maybe you're right. Maybe I need to do some writing, because that might be kind of cool. And I'm sure it'd be a really frustrating research process, but it might be worth it in the end.
No, absolutely. It sounds like your knowledge and research is needed out here. Thank you guys both so much for being here. I think this was a great episode. I think people will be excited to learn about this and listen in. So I appreciate it, and I will see you all next week.
Thanks, Professor.
Thank you.
This is Tom Fox. I'm the producer of Classroom Insiders Season 2. Thank you so much for listening to this episode. And if you enjoyed it, I hope you'll subscribe, rate, and review wherever great podcasts are listened to. We've linked to Washington and Lee and Professor Karen Woody in the show notes. So if you have any questions, reach out to her through the contact information. Classroom Insiders is an award-winning podcast, which is a special production of the Compliance Podcast Network.